deal in the matter of Standard Life Assurance Limited and Gleeds and others.
Thank you. Mr. Selby.
Mr. Moran.
Oh, it's Mr. Moran.
May it please your
Before you
ladyship.
do, can I just... Yeah. Thank you. It is Mr. Moran. It's Mr. Selby for the respondent. I am terribly sorry. Forgive me, Mr. Moran.
May it please your ladyship and may it please your lordships. I appear on behalf of the first appellant, BDP,
Yes.
who are the fourth defendant in the action,
Yes, we've read the papers.
and with my learned friend, Mr. William Webb,
Yeah.
and my learned friends, Mr. Selby and Mr. Monroe Morrison, appear on behalf of the respondent.
Yes.
May I
So-
just quickly check that, as well as the electronic bundles, the court has copies of the 3 core bundles,
Yeah.
1 supplemental bundle of documents,
Yeah.
1 bundle of authorities, and 2 emails which were sent through yesterday by the parties to summarise what's happened to the claim over the last year.
So, insofar as those emails are concerned, Mr. Moran, yesterday we received the amended particulars of claim. Is that what you're referring to? And this morning?
Yeah, I should have added, I believe the respondent sent the most recent pleading, which I'll come to in due course, as well as a short sub. That is our document, so
Yes.
that's from the appellant. There's 1 document with a table with 3 columns, and there's a Word document.
A table with 3 columns, that's at the back of my Part B particulars of claim.
That is the respondent's summary sent yesterday, and that, your ladyship, is our summary sent yesterday.
Right.
We won't really need to go to them very much if at all,
No.
but I'll go to ours in due course.
Well, before you go anywhere, Mr. Moran, you've talked about 2 emails. Are they different to the...
No,
to the
as I understand
attachments?
it, those are the 2 submissions I'm referring to that contained
Right.
from the respondent, the pleading plus their summary of the case.
So there was nothing in the substance of the emails that we should have
No,
been alerted to?
no. It's just to update the court on where the claim has gone since the application to strike out,
Yeah.
which I'll describe in my submission.
Yeah, that's fine, thank you. And the other thing to ask is this. I know that you've both been pressed by the Court of Appeal Office to consider the time estimate again, because
Yes.
2 appellants dropped out.
Yes.
And the message we received back was that the parties confirmed that 10 hours was necessary. I was rather surprised that it was in hours, and I asked my my judicial friend, my Lord Justice Coulson, whether it's common for the TCC bar to refer so much to hours rather than days.
Yes, well, that's news to me. I think what happened was when the two other appellants dropped out, that they weren't going to take up much time anyway because they were repeating the submissions. My learned friend and I consulted. We thought between us at that stage it would take 8 hours, just over 1.5 days. So I think we thought safe to leave it at 2 days. I'm afraid I don't know what was communicated in terms of hours to the court. The good news is, I don't think this is going to take anything like 8 hours.
Neither do we.
I'd rather hope to finish my submissions by lunchtime.
That's what we were going to ask. Because, and the only reason I say that, Mr. Moran,
Yes.
is that, of course, my Lord Justice Coulson gave permission in this case, and it was quite pointed.
Yes.
So that we did expect a rather focused approach to the appeal, and we thought that there was one actually from the skeletons.
Yes.
Which is why we couldn't understand why people were saying 2 days or even 1.5 days.
No, I think out of abundance of caution, we thought 1.5 days. There's further good news, which is that ground 3 is not being pursued.
Right.
You'll find that at page 14 of first volume of the core bundle. So it's just grounds 1 and 2. Because having regard to the reasons given by the court when permission was granted, to focus on points of principle, we took the view that ground 3 was too fact-specific and therefore we're dropping that. So that will shorten matters as well.
Thank you. Is there any other housekeeping we need to do?
No?
Right, thank you. Thank you very much, Mr. Moran.
Well, there are 2 central issues that arise in this appeal. First, whether, and if so in what circumstances, can a claim for professional negligence be pleaded on an extrapolation basis? And secondly, whether the judge should have but failed to approach the strikeout application on a two-stage basis, and if he failed to do that, what should he have concluded had he done so? Now, I want to structure my submissions in 6 parts. The first is a very brief series of observations on the case as a whole. The second will be a quick update on the proceedings since the application to strike out in January. That's where the emails will come into play. The third will be a short consideration, you'll be glad to hear, of the relevant parts of the pleading. The fourth will be a consideration of the relevant law and how the judge approached the law. The fifth will be a more detailed consideration of the section of his judgment where the reasoning is set out. And the sixth and final bit will be a summary of the reasons why we say the appeal should be allowed. So starting with the introductory points, there are 3 points I want to make. First, as the court is no doubt well aware, there's a fundamental difference between this case and the use of sampling and extrapolation in trying a typical final account type dispute. When in construction disputes, as the court is aware, there are often a large number of disputed variations or defects or delay events. And while they tend not to be pleaded extensively, nevertheless the basis for the individual items that make up the claim will be set out, typically in a Scott schedule. The other characteristic of normal construction claims is that there's usually been some sort of prior claim submission, or at least a consideration of what the factual basis to those individual items are. In the present case, things are very different. There's no attempt, as I'll seek to demonstrate on the pleadings, to explain the specific postulated defaults connected to the varied work that forms the basis of what we call the extrapolated claims. And further, on the respondent's own case, none of the variations that form the basis of the extrapolated claims had even been investigated by the respondent, let alone the subject of a prior claim prior to the pleading of the amended particulars claim. The second point I want to make is a linked point in that there is a fundamental difference, as the court knows, between a case where the claim is adequately pleaded, but as a case management exercise, it's to be tried and evidenced by way of sample extrapolation, and, on the other hand, a case such as the present, where the investigation and pleading of the claim itself has been carried out by way of a sample and alleged viable extrapolation. Now, in due course, I'll submit that the learned judge's reasoning seemed to conflate these 2 points, which are very different situations. We do not attack the use of sampling and extrapolation as a case management tool to an already properly pleaded case, and that is, we'll see, what the existing authorities really deal with. Our attack is on a professional negligence claim being advanced by extrapolation, absent adequately pleaded, systemic, or repeated alleged defaults in relation to the similar kinds of work on the part of the defendant. The third point I want to make by way of introduction is that one needs to note that the claim that was before the judge on the strikeout application was largely one based on extrapolation. Standard Life's claim had 2 principal elements. There was the variations claim, so that was a claim for damages for extra sums said to have been paid because of lateness, inadequacy, etc. in the design service provided by BDP that led to the need for varied work. And then the other half of the claim was the loss and expense claim, sums allegedly paid by Standard Life to the contractor as a result of delays caused the progress of the works by those defaults in relation to the variations claim. Now, in respect of each element of the claim, Standard Life pleaded what we've referred to as a conventional or unextrapolated claim, and what we refer to in the skeleton as an unconventional or extrapolated claim. The conventional claim, which Standard Life referred to in their pleading as their alternative claim, is one for damages for the extra costs arising out of specific allegations of negligence breach of contract on BDP's part, associated with only 122 specific variations, and those are the ones we'll see in due course were set out in Schedules 1 to 4 of the pleading, connected with only 4 specific categories of work across the whole development: residential fit-out, secondary steelwork, cladding and roofing. And in total, that claim, the conventional claim, on the face of the pleading, amounted to £9 million, £3 million in relation to the direct costs of the variations that were being claimed as damages, and £6 million in relation to associated loss and expense that had to be paid, it was said, because of those defaults. But the development, as the court will no doubt have noted, was a very large residential commercial development. It covered many more categories of construction work and thousands more variations. And that's where the unconventional or extrapolated claim came in. That was referred to by Standard Life as its primary claim, and was said to be based upon inferences that could be drawn from the specific analysis and pleaded case in respect of the 122 variations. The unconventional or extrapolated claim was for damages in respect of the extra cost incurred to a further, on our calculation, 3,482 variations. So about 30 times the number of variations specifically identified and pleaded in Schedules 1 to 4 as part of the conventional claim. And including, and this we say is very significant, in the main, further variations relating to completely different categories of work to the 4 I've just outlined. We'll come to those in due course. But amounting, nevertheless, against the BDP to 16.3 million in direct costs and 3.7 million in damages claimed in relation to loss and expense. So together, the extrapolated claim, extrapolated variations claim and the extrapolated loss and expense claim made up the majority, so that's about 20 million, of the then overall pleaded claim against BDP of about 32 million.
So another way of looking at that, is this right, is that, as you say, it's about 30 times the number, and it's about 3 times the money.
Yes.
So that's a pointer, isn't it? That we mustn't be beguiled simply by the number of variations. It's 30 times the number of variations, but it is, in inverted commas, only 3 times the money.
Yes and no, because the number of the extrapolated variations, which were then on the pleading, said to justify the £20 million extrapolated claim, becomes relevant when you try to understand what could conceivably be the case on breach as extrapolated from just 122. But I'll come back to that. In terms of, I just want to quickly update the court on the proceedings. That's where the emails come in. In short, since the judge's order in January, Standard Life served its first replacement, or what it calls its fresh Part B, the amended claim, in July 2021. And recently, Standard Life has compromised its claims against the 5th and 6th defendants, the original co-appellants in this case, and served a further proposed fresh amended particulars of claim, that's last week, to reflect both that settlement and a further order of the court, which we don't need to trouble this court with, which was another squabble over the pleading, which led to an order that Standard Life provide further particulars of its case on quantum. So it's incorporated that into its amended pleading from last week. Now, those pleadings are not relevant for the purposes of today, save for tangential reasons, which I'll come on to. But in order to understand where the claims went over the last year, and those from the original pleading, which is the subject of the strikeout, to where we are today, the summary is as follows. The first fresh amended particulars of claim, that's the July document. If you look at my instructing solicitor's table, which is that document, you'll see a summary of what changed. And at the top half of it is the primary case, so that's including the extrapolated claim. And one can see that the total of the primary case went from 32.8 million at the time of the strikeout application to 22 million odd as of July. And if you look then at the alternative claim in the table below, between those two pleadings, the alternative claim, so that excluding extrapolation, increased from 12.8 to 20.4 million. Now, those changes essentially reflect the fact that the extrapolated variations claim that we were complaining about shrunk from 16.3 million, as at the date of the application that we're appealing the order from, to 1.6 million. And the extrapolated loss and expense claim reduced to 0. Now, of note is that in order to revise the claim down in this way, Standard Life had analysed only an extra 110 variations, in addition to the 167 which it had analysed in order to arrive at the 122 that it pleaded in the first version of the amended particulars of claim. Now, the second point is that although a further 110 were analysed, the new pleading, which has led to the reduction of the extrapolated variations claim and loss and expense claim by 90%, was on the back of merely pleading a further 52 individual variations to the 122 that were originally included in Schedules 1 to 4. And only 16 of those were pleaded against BDP.
That's 16 of the 52.
16 of the 52. So I'll come back to this when we get on to proportionality, etc. Because what's essentially happened is that the extrapolated claim against BDP anyway has all but evaporated. There's still 1.2 million left, as we'll see, simply because BDP have analysed 110 further variations and pleaded 16 of them against BDP.
And just so that I'm understanding this table correctly, that is because if we now look at, if we take the up-to-date position, the primary case, so that includes extrapolation, is 20.4 million. And the alternative case, that's to say without extrapolation, is 19.1. I mean,
yes.
I appreciate these are your figures and there may be debate about it, but at the moment you're just showing us this,
yes,
to show this is part of your quick update.
Yes, and your lordship's jumped ahead of me because you've now gone on to the fresh amended particulars of claim served last week.
Okay,
right.
but the same point is true whether we look at July or October.
Yes.
The difference between the figures is very small.
Yes.
And it is the difference between the figures that represents the value of the extrapolated claims on your case. If you just have the extrapolated claims,
it's a little bit more complicated because when the headline number comes down, that's for two reasons.
I'm not interested in why it's come down, just it's come down.
It's come down.
So that at the moment, the primary case which excludes extrapolation is 20.4, and the alternative case which excludes extrapolation is 19.1 or 9.2.
Yes. And therefore the difference is the extrapolated variations claim, which is 1.2 million now.
Yes. So is this right? On the new figures, the appeal is worth 1.2 million, not 20.
Well, the appeal, of course, is referable to the...
I appreciate that, but in terms of value to the parties, yes, commercially now,
it's reduced.
Having our regard to the real world.
Yes. It's gone from 20 million to 1.2 million. Now, in substance...
I think it definitely should be a day then.
It definitely should be a day. This, of course, appeared in July and October.
No, I understand that. No. It's not a criticism. It's not a criticism. It's just a observation.
It's an observation. The point of principle remains because it's obviously more stark, we would say, unjust and absurd if you're claiming 20 million out of 32 based on extrapolation. But notwithstanding the last year and 2 attempts to make the case more particular and get rid of extrapolation, we've still got a claim of 1.2 million based largely on the same point on extrapolation. So the point remains. There's also, of course, the wider significance of this decision and this permitting this approach to pleading a professional negligence case, which is really what this appeal is all about, although it does have still diminished, we would accept, relevance to this particular case. Now, if I can move on now to the pleading as of the date of the strikeout application, at this point I'm going to have to repeat the forage that the judge referred to in his judgment of going through it. It's at tab 16 in the third 4 bundle. The relevant parts are summarised in the judgment at paragraphs 33 to 62. But
and is any point taken as to Mr. Justice Carr's summary of the
no.
pleadings?
No.
Because, I mean, he regarded it as not an exercise for the faint-hearted.
No, it wasn't.
And so anything that's summarised that avoids the exercise being done again, I certainly personally would embrace.
Well, yes, except for my purposes, there are some bits of it one needs to go to really put in perspective the lack of text, let alone explanation, of the extrapolated claim. Now, there are 3 points, before we go through the relevant, or I just note, rather than go through, note the relevant paragraph. There are 3 points that I'd ask the court to take from this. Nearly all the text in this voluminous pleading, and this is only one part of the overall pleading, but it's the part that applies to the design team.
Sorry, it was page, which of the, just give me the page.
We start at 722 of tab 16 in bundle 3. This is part B pleading. It was at this stage 127 pages long. It had 15 annexes and 4 schedules, some of which we'll go to. But the 3 points I want the court to take as we go through are as follows. Nearly all the text in part B was concerned with the conventional claim, as particularised as we'll see in schedules 1 to 4. Secondly, I think as the judge accepted, the basis and extent of the extrapolated claim needs to be teased out of it. It's not actually spelt out anywhere. You've got to sort of deduce it from various other tables and text. And the third point, which is the salient point for present purposes, is that we submit there's no coherent explanation or in relation to the extrapolated variations claim, what the case on breach and negligence or causation of loss is, beyond an assertion you can infer from what I have pleaded in Schedules 1 to 4 in relation to the 122 variations, that if there was fault in relation to those, that there must have been equivalent fault in unidentified further parts of the works, but encompassing every other variation, because that is what the case boiled down to. If I can take you to paragraph 5 very briefly, page 724, there we'll see the origin of what's referred to as the contract administrator's instructions, the CAIs, and the confirmation of verbal instructions, the CVIs, and the averment that there were 3,500 of these issued on the project. There were also delay notices, and the amount paid to the contractor for the additional varied work and the loss expense was 50 million odd, and that's the beginning of the claim. You turn over the page to paragraphs 8 and 9. Paragraph 8 effectively introduces what I'd suggest is a total cost claim, because at the start of the claim is that the 50 million we've just seen referred to is then whittled down to extract what the claimant considers to be variations which Standard Life itself instructed, and those delay notices where Coulson didn't blame the design team for the delay. So those are extracted out. What's left then is really summarised in paragraph 9, and it summarises in paragraph 9 the total claim at 38 million and breaks it down between the variations claim, which is 23.6, and the 10.7 for loss expense. At this stage, it's lumping together the conventional claim and the unconventional claim. So this is just the high-level claim. Then over the page, at paragraph 11, you get the introduction of the 4 categories of variation, which are really at the heart of the case: the residential fit-out, structural steelwork, cladding, and roofing. And it explains at paragraph 12 how 55.8% by value of those variations, so only just over half of the variations in those 4 categories were assessed. 83.1% of those, it is contended, are to be attributed to design team negligence. And it's that 83.1% of 55.8% that becomes the 122 variations particularised in Schedules 1 to 4. and just as an aside, it's that 83.1% that is basically the figure that's then applied to generate the extrapolated variations claim by just applying the percentage to the face value of the extrapolated variations, and in due course the loss and expense claim. So that becomes the key to the assessment, effectively, of a figure to claim as damages. Then paragraph 13 is quite an important paragraph because it really sums up, it's the high point, I think, of the pleaded case into how this works, how the extrapolated claim works. Paragraph 13 says, based on this analysis, so that's the analysis in Schedules 1 to 4, the 122 variations, Standard Life will invite the court to draw the reasonable inference that on the balance of probabilities, all variations, bar those arising from the matters set out, paragraphs 88.1 and 82 above, so those are the matters that Standard Life instructed or aren't blamed on the design team, arose from the matters set out, for which Standard Life does not contend design responsibility, were caused by the negligent performance of the design team. So what's happening there, although it's not being said in terms, is that is the extrapolated claim. There's just been an assertion that based upon a claim for 3 million, just over 3 million in direct costs, a truth of 122 variations, the whole of the extrapolated variations claim and its associated loss and expense claim of £20 million is going to be reasonably inferred. And that is really the best we get in terms of how the claim works. Just to follow up, paragraph 14 then refers to loss and expense, again at high-level terms. And then the remainder of the body of the amended particular claim develops the case on breach causation loss, but only by specific reference to Schedules 1 to 4 and the 4 categories of work that Standard Life has analysed. And so we can move on to an example of that in relation to residential fit-out, which is at paragraph 74. And that the pleading does this for the 4 categories. And I'll just take your lordships to just one to show how it's done.
74.
Paragraph 74, page 745, the bundle. So this is the first of the 4 categories of work that have been analysed and particularised in Schedules 1 to 4, which we'll come on to. It's the residential fit-out works. And the plea is, as is particularised more fully in Schedule 1, these variations were necessitated by the lateness, inadequacy, inaccuracy, incompleteness, and uncoordinated nature of the design information provided by the design team. And then on to paragraph 76, which is at page 747. Again, this is under the residential fit-out works. The pleading continues, as a result of the matters described above, so that's a reference to the breaches, Standard Life was put to significant additional cost. See Schedule 1 for particulars occasioned by these design failings. And at this point, if we then go to Schedule 1 to see how this was specified, if we go to page 871 in the bundle, you'll see the first page of Schedule 1. And I just intend taking lordships just to item 1, just to give you a flavour of how specific the 122 items and related varied work and related breaches were. And the way the pleading worked was, this was the first category of works that was being pleaded to. There's a summary in column A. The allegation is incomplete or uncoordinated design. There's a value in column D, 45. That's the face value cost of the variation, which is then claimed in damages. That raises another issue, but that's not for this court today. But that's the amount being claimed in damages in relation to item 1.
You say that raises another issue.
Yes.
Is the other issue related to, did they get value?
Well, the other issue is they're claiming the whole cost of varied work as damages, when plainly there would have been some cost.
Yes.
If not exactly the same cost. But
it's a pity we're not deciding that. That's a much more interesting issue, and one that, a bit like the issue we are deciding, the authorities are very threadbare.
Yes, well, this issue then became a subject.
Perhaps you'll come back in 18 months' time after the trial.
Well, let's hope not.
We'll look forward to it.
Yes. But that issue
So that is the issue, but obviously that's not for us.
yes, that was the subject of a further application and then further amendment which came in last week to explain how this works as a matter of causation. Okay. Anyway, but it's not for now. But in terms of how the pleading on its face works, that's the sum in damages that's been claimed, it's the whole cost of the variation.
Yeah.
And then you see the cause of the CAI in column E. In this particular item, it's to do with incomplete or uncoordinated design of the service risers, a very specific part of the residential blocks. And then there's a category of breach. You see, and this becomes relevant for future submission of mine, that both CJP and BDP were being blamed for this particular item. And not all items were blamed on more than one of the defendants, but this was. And then you see there's categories, C, D, D, E, etc. And those reflected categories that the claimant summarised its case in relation to Schedules 1 to 4 by. And although for the purposes of the amended particulars of claim, there was no explanation of what those categories were, there is in the original particulars of claim, which in due course was adopted. So we need to go back to the original to see what that categorisation means. And the original is in the first core bundle at tab 12, page 255.
Mr. Rand, so I can follow this. I can't see the categories here.
Oh, okay.
Are they on Schedule 1?
Yeah, so if we go back to schedule, page 871 of the bundle.
Yes, I've got that.
If you see column F.
F, yes, it says defendants responsible.
Yes, and then
after...
after...
I see, and then it's the initials are, yes, I do see.
Then there are letters, C, D. In fact, there are 5 categories, A to E.
Yeah.
E was contract administration, we can ignore that. But A to D was a broad categorisation, and we see that explained. If we go to tab 12 in bundle 1, the original particulars of claim, at 255, this was the introduction to Schedule 1, which wasn't actually produced as part of the amended particulars of claim, but still applies to help you understand what the categorisation is supposed to mean. And you see at page 256, at paragraph 3 of the introductory text, there's an explanation of what categories A, B, C and D mean.
Yes, thank you.
A being late design, B being inaccurate design, C being incomplete design, D being uncoordinated design. So the way the pleading worked was that those categories of breach related back to the main text, which we'll look at in shortly of the pleading.
Yeah, okay.
And then within those categories, the categories were allotted to individual items within schedules, and then there was a specific explanation of what the defect and the problem was in a particular. And obviously, we've just looked at one that's specific to service risers. If you go on to page 873 in the third core bundle, look at item 2, you'll see that the next item is floor screening. So these are completely different. In the residential fit-out, Schedule 1, they're different items of work. And of course, Schedules 2, 3 and 4 then dealt with specific categories of work, secondary steel work, etc. But that's how the pleading was framed. And then, if one goes back to the main body of the pleading, at paragraph 119, 770 of the bundle, we see that the same approach is then taken after setting out the case in the way I've just indicated in relation to residential fit-out. Then the pleading addresses secondary steelwork, which is Schedule 2. I won't take the court through, but in paragraphs 119 to 174, the pleading sets out a similar approach to the claim in respect of the 3 other categories of work, namely the secondary steelwork, cladding and roofing. And the items and the variations that have been claimed as the result of negligence in relation to those works are then spelt out in Schedules 2, 3 and 4. So that's how the case on breach, as it were, in relation to the variations, the 122, is is particularised. And then breach within the main body of the pleading is addressed at 175, paragraph 175, page 804 of the pleading. And I don't need to, although I should put out 8 pages of generic breaches alleged just against BDP. But this doesn't add anything to the schedules because it's just generic high-level breaches that then cross-refer to the schedules. So the main body, just at some length, goes through the categories of breach at a high level and cross-refers to the schedule. So it's the schedules you look at if you want to understand the cause of action being relied upon in relation to the 122 variations. And then in terms, where it gets a little bit opaque in terms of understanding the extrapolated claim, is at 186 onwards. Because of course, so far as page, I beg your pardon, I should have had it, page 826.
826, yep.
No, that's the wrong number. Beg your pardon, 827. Because as the court will have noticed, we've now up to paragraph, well, section H of the pleading, and there's been no reference to the extrapolated variations or loss and expense claim, except that very introductory reference at the beginning of the pleading.
12 and so far, it's 12 and 13 that matter for the extrapolated.
Paragraph 12, yes.
Paragraphs 12 and 13, yeah.
So the vast majority of the rest of the pleading is just addressing the specific case, which everyone understands, in relation to the 122. But then we get, at 186b, reference to the primary and alternative claims, and they're said to be broken down in a spreadsheet, in the Part P quantum spreadsheet. We don't need to go to the spreadsheet because the spreadsheet is actually then replicated in the main text, which we'll see in a moment. Next paragraph of relevance is 194. Paragraph 194 at page 829 of the bundle. This is where the variations claim is now identified in total as being 23 million. And this is the first time I think we get a breakdown of it between the extra cost of the conventional variations claim. That's in subparagraph 1 to 194. That's the 3.7. But of course, that's against all of the defendants. So if you go over the page, the table, if you want to understand the claim against BDP, the conventional claim for the 122 variations, the direct cost claim as damages, you go over the page to the BDP responsibility column, you go down to the bottom, and there you see the magic number, 3,024,000.
And is that the same as the spreadsheet that you were referring to?
It should.
You said you didn't need to take us to the spreadsheet because it was replicated in the pleading, is it?
Yes. Yeah. And then subparagraph 2 then deals slightly more opaquely with, well, and it doesn't say so, with the extrapolated variations claim. But you'll see that the only number identified against BDP is 19,304,000. That isn't, in fact, the extrapolated claim. The extrapolated claim is the difference between 19,304 and the 3 million above. So a little bit, so under the radar, this is the first plea as we understand in the pleading, that there's an extrapolated variations claim of 16 million odd, but it doesn't actually say so. You've got to deduce that from comparing the two numbers. And then moving on to paragraph 201, which is at 833, we see how the loss and expenses extrapolated and specific claims are explained for the first time. And you see in paragraph 201 in the second sentence, after those omissions, the total contractor's loss and expense amounts to 10.7 million, which Standard Life claims from the defendants. As set out at paragraph 195A above, 6 million of the 10 million has been attributed to the works packages which have been analysed. So just pausing there, although it's not saying
so. Where are you reading from, my fault?
Paragraph 201, page 833, the second sentence in paragraph 201.
Yeah.
And it's the third sentence that reads, as set out at paragraph 195A above, 6 million of the 10 million has been attributed to the works packages which have been analysed. So again, it's not saying so, but that's the direct, that 6 million is the conventional claim for loss and expense that's been claimed on the back of the 122 variations. That's not being attacked in the application. But then it goes on. In respect of the balance of the 4.6 million, Standard Life apportions liability for Costain's loss and expense between the parties as follows. That, although it's not said, is the extrapolated loss and expense claim. I should also, for the court's note, just point out that the paragraphs that were the subject of the application to strike out, so that certain paragraphs were identified as being key to the extrapolated claim. Although maybe that the court has seen already that it's not very easy to actually pinpoint where the extrapolated claim is clearly set out, not so far. But paragraphs 194, which I've taken you to, and 201 were specifically identified as paragraphs that should be struck out, and the judge refers to that in his judgment, as was paragraph 202, and the next paragraph I want to take you to, which is 219, which is at page 842. So, and where we get to, at the very end of the pleading, I think it's the first time the words extrapolation have been used to identify what might be going on in terms of the claim. But again, one has to sort of forage through these tables to actually understand what it is. But at 218A, there is a summary of the primary claim. And the primary claim, of course, includes extrapolation. And if you look at the column total about claimed against BDP,
218A.
218A.
It's duplicated.
There are two of them. One's at page, the one I want you to look at page 842.
All right. Sorry, I was looking at poor record keeping. All right, yep. So there's two 218As. Anyway, this is the one at 842, yeah.
And this is the plea summarising what the primary claim is. For present purposes, if the court could just focus on the column claimed against BDP,
yeah,
you see that the summary is broken down into 4 subtables. The first table is CAI, CVI, so that's the variation claim. And you see the total is 19.3 million, but the figure above it is described as the balance by extrapolation, 16 point. Do you see that figure?
Yeah.
That is the extrapolation claim, and I think it's the only place where it's described as such. The figures above it for roofing, cladding, secondary and residential are the figures that are explained in Schedules 1 to 4. So in terms of the pleading and where the extrapolation claim is explained, and then this is really as good as it gets, which is you've got to understand what this table is doing, to deduce that of the 19.3 million claimed for damages in structural variations, over 16 million are being claimed by way of extrapolation beyond the variations pleaded in Schedules 1 to 4.
And the 3 million is referable to Schedules 1 to 4.
Yes, and the same point, the loss and expense is the same point. The subtotal figure at the bottom of that subtable of 9.8 million is the total claim, the extrapolated and the conventional claim, but the extrapolated element is the 3.72 million. And then just for completeness, if one moves on to page 844 in the bundle, you then see the summary of the alternative claim. And I won't take you through those numbers because all the alternative claim is the primary claim minus the extrapolated sums. Now, just to be fair, I mean, I in terms of bringing to the court's attention, as it were, at its highest, how this we've been through the pleading. We've seen that there are a couple of paragraphs at the beginning which refer to the extrapolation exercise. And we've seen this table that has a line item using the word extrapolation. That's it so far. But also appended to the particular claim was a list of the extrapolated variation. So the variations beyond the 122 that the extrapolated claim was relating to. and you find that at in the supplemental bundle at tab 4. Does the court? You should have a quite long document going from page 113 of the bundle to 192, which lists out a large number of further variations. And you can see that there is no, it's literally just a list. So there's no detail of the basis for the criticism, which of the categories even of criticism from Schedules 1 to 4 might be applicable, let alone details of lateness, incompleteness, the rest of it. It's literally just a list. And note also the cost code column, which broadly describes what the variations relate to. And as I understand it, anchor 1 is to do with tenant fit-out requirements being translated into variations. Go on to page 119 of the bundle. You'll then see another category of work, architectural metalwork. Does the court have that?
Can you give me the page again?
119, and the bottom third of the list then turns into a series of variations to do with architectural metalwork.
Mr. Moran, why are there some with no value?
Well, that's a good question.
Right.
There were various... This list was looked at in much more detail in the application, and for various reasons, which the judge acknowledged, a lot of it didn't make any sense in terms of specific points such as that, or the other points that the judge noticed, which we're not going into that line by line analysis as to why this doesn't make any sense. But for present purposes, the point to note is that this was as good as it got on the pleading in terms of what the extrapolated variations claim consisted of. It's literally a list of variations, and the point I want to emphasise at this stage is that the cost codes, the work categories, were in large part, not exclusively, but in large part to do with completely different categories of work. So the anchor 1 work, at page 123 we see basement floor work, at page 119 we see architectural metalwork, page 126 we see brickwork and blockwork. At 136 we see carpentry and joinery. And this becomes relevant to my submission in due course, that it's, even if one were to accept it's a viable case to extrapolate professional negligence in the round, it's difficult to understand how conceivably established professional negligence in relation to late design in relation to, say, the cladding can have any probative value, let alone explain remotely what the case is in relation to the carpentry and joinery variations. So the point I just wanted to make is that on the face of the pleadings, one has a universe of extrapolated pleadings related in the main to categories of work that are nothing to do with the 122 that have been pleaded in a conventional way.
Mr. Moran, I know that you want to tell us how difficult it was for your side to understand all this, but I was actually quite interested in knowing why these don't have numbers in and what you know about it, and you haven't actually told me.
I think they were just errors. But
right. Okay, that's fine. That's an answer. Fair enough. Because
what happened was when that list was reviewed as part of the first amendment to the claim in July, a lot of matters were taken out because they couldn't possibly have fit within the timescales that various defendants were appointed to provide services. There were other errors that were just whittled out. So if you look too closely at it, it's factually a bit of a muddle, which is a point that was made before the judge. And we'll see that the judge acknowledges this when we go to his reasoning. But the specific answer as to why a particular item has a 0, or even why it's even in there, is not explained and is still beyond us. Anyway, Now, standing back from the pleading, I'll come to the further information in due course, because we've just looked at the amended particulars of claim, and as you might imagine, that's triggered rather belligerent defences from all of the design team, and requests for further information as to, well, how on earth is this case being put in relation to the extrapolated, and we'll come on to that in due course. But standing back from the pleading as it stands at the moment, where we get to is that there were a total of some 3,600 variations issued on the project. The claimant, by its own admission, only looked at 167 of those before pleading its case. By its own admission, it had carried no analysis at all of the remaining 3,500 odd, asserting that it would be disproportionate to expect it to do so, or that it had insufficient documents. But it did plead an orthodox case of breach of contract negligence in relation to only 122 of the 167 variations which it looked at. For the other variations that were included in the claim, i.e. the 3,000 odd extrapolated variations, there is no pleaded case whatsoever as to breach or causation of loss. There is simply the extrapolated variation list attached to the pleading and those high-level assertions at the beginning of the pleading, paragraphs 12 and 13, I think. But there is, notwithstanding that, an asserted claim for £20 million in damages alleged to be referable to extra direct costs for those variations and associated loss and expense due to delay caused by them. And of course, the final point to note is that the extrapolated variations, the list I took you to, were connected with a broad range of subject matter, highway work, substructural work, scaffolding lifts even, very largely distinct from the categories of work that had been made the subject of Schedules 1 to 4. Now, the only additional information that's been provided, was provided as the date of the application, was in the RFI response, which I'd like to take the court to now, which is in Supplemental Bundle Tab 2, page 49. And the first request that was made of the paragraphs in the pleading that seemed to deal with the extrapolated claim was that, you can see Roman numeral 1, 2, 3 and 4, for particulars of the alleged negligent performance that is alleged with the cause of the volume of additional varied work associated with the balance of 87% of all variations. All facts and matters relied upon in support of the contention that it would be fair and reasonable to make the extrapolation. 3, all facts and matters relied upon in support of the contention that it would be reasonable to make the inference, and that's a reference to paragraph 13 that Lord Justice Coulson just reminded me of. And then even details of legal authority relied upon in support of the case on extrapolation, etc. And the answer over the page came, and I'd like to draw the court's attention to the following. In response 1, Roman numeral 1, in the second sentence, it reads, in summary, Standard Life alleges that negligent performance of the same kind, mutatis mutandis, as to that which has been identified in both Standard Life's analysis and the analysis of Borough 4 as the cause of the substantial majority of CIAs and CVIs analysed, was also the cause of the balance of all variations on the project. And then I'll come back to that purported reliance on mutatis mutandis in a moment. But then Roman numeral 2, then second sentence of the plea, without prejudice to that, it's sufficient for the 4th to 6th defendants to understand that the facts and matters upon which Standard Life will rely in support of the extrapolation inference are those set out at paragraphs 10 to 12 and 182 of the Part B particulars of claim. In summary, in circumstances where no defendant has yet provided any explanation whatsoever for any variation of the project in response to Standard Life's complaints, the factors which support the reasonableness of Standard Life's approach include A, the fact of the variations and Costain's assertions in respect of them, B, the current absence of any explanation by any defendant as to why these variations came about, C, Borough 4's analysis of July 2014. Just pausing there, you've seen 2 references to Borough 4's analysis. It's not in the bundles before you. It didn't feature in the judge's judgment for good reason, because there's no further detail in the Borough 4 analysis than there is in that list of variations I showed you of to what the nature of the breach might be. And then over the page, we get to really the bull point.
They're a defendant, aren't they, Borough 4? I saw that they were number 2 on the list. I don't know if they're playing any active role.
Yes, I'll have to take instructions on where we are on that now.
Yeah.
Then over the page, it's, subparagraph D, I think, is really the bull point that Standard Life wanted to rely upon. They say the impracticability of analysing every variation given the enormous time and cost entailed. From the analysis it has undertaken so far, Standard Life estimates it will take roughly 10 months and would cost approximately 2 million in expert fees to review all of the 3,604 variations. And just pausing, we'll come back to this, but as I noted earlier, what's in fact happened is when just 110 further variations, the largest ones, were analysed, 90% of the extrapolation claim has gone, and only 16 further variations have been pleaded against BDP. So we'll be submitting this suggestion that disproportionality of that kind would have been involved was plainly absurd and has been demonstrated as such by what's happened since the application. And then at the bottom of the page, Roman numeral 5, it's averred, without prejudice to the foregoing, without any waiver of privilege, Standard Life's approach has been to employ systematic sampling by cost value within a stratified sampling frame. Not sure what that means, but anyway, carrying on. In other words, the population under scrutiny, i.e. all variations of the project, has been divided into subpopulations, i.e. project components such as residential fit-out, secondary steel, etc. From those subpopulations, the 4 headline project components, which form the subject of Schedules 1 to 4, was selected for analysis based on total cost value. And then it lists out the top 6. And in fact, the top 6 show that it didn't choose the 4 most valuable because the M&S category and the M&E weren't included, even though they were in the 4 most valuable. Anyway, at the bottom...
Which was the other one that wasn't M&S and M&E?
M&E. You see their table there?
Yeah. 1 and 4.
They didn't do what they were asserting they had done. They didn't choose the 4 most valuable categories. They chose, for some reason, only 4 of the top 6. And then at the bottom of page 52, the plea goes on. Within each subpopulation, individual variations have been selected for analysis systematically by prioritising those of highest value, etc. And over the page, this is the confirmation that only a few have actually been looked at. The third line reads, it's confirmed that the total value of CIs and CPIs analysed as set out in paragraphs 12, 188 and 194 represents all variations which have been analysed today. So that's a concession that not only were 122 specific variations only pleaded specifically to, only 167 were ever analysed before the whole pleading was put together. So just reflecting on that plea, in my submission, that further information shows that the claimant was not alleging that there's any form of common or systemic breach committed by BDP as part of its case. The reference to mutatis mutandis appears to have been introduced to give the impression that there was some form of repeated or common default. That phrase, of course, means making necessary alterations while not affecting the main point at issue. But it's incomprehensible in my submission how a plea of mutatis mutandis is supposed to apply as between 122 pleaded variations in Schedules 1 to 4 concerned with 4 particular work categories and 3,000 odd extrapolated variations connected with completely different work categories. There's not even an identification in the extrapolated variations list of which of the categories A to D, which you saw in the introduction to the Schedule 1 pleading, the extrapolated variations might fall in. There's not even an indication of which are to do with late design, which to do with incomplete design. To then just baldly plea that the breach relied upon can be understood because it's mutatis mutandis is, with respect, gobbledygook. What is the main point in issue that it's alleged applies to the 3,000 odd variations. It's not identified, it can't be identified. Now, moving on to the law, which is part 4 of my submissions. The judge summarised the...
Before you get there, Mr. Moran, when you say that, and this is part of your complaint, that the vast number were not even analysed before the pleadings were served.
Yes.
How are you defining analysed? Do you mean analysed in terms of responsibility and quantified, or merely responsibility?
Well, I'm using the word that's been used by...
I know, but I'm asking you what your case is, given the introduction.
Well, whatever they meant by analysed, I'm assuming it means hasn't been looked at all. But I'm assuming that means hasn't been analysed for the purposes of understanding the criticism of default, the negligence, and the loss that flows from it.
Yes, it's just that when you were introducing the case, you were talking about the differences between those cases where the particulars are not dependent upon a claim of extrapolation beyond the damages claimed, and this case, which you say claims extrapolation in order to found the negligence. And that's why I'm asking you now, in terms of your submissions, when you take us to these parts of the pleadings, is it all going to this introductory remark that you've made, that the lack of analysis goes to the lack of identification of the cause of action?
Yes. It's the explanation for why there isn't an identified cause of action for the extrapolated variations is Standard Life's own admission that it hasn't analysed them. And I'm understanding that to mean hasn't looked at them.
Yeah. You don't need to get so perky about it. I'm merely asking to know what your points are as we go along, so I can understand your arguments.
Yes, a lot of points come out of that one point, actually.
Yes,
because it forms an abuse, say.
But this is why my Lord's question, my Lord Justice Birss's question, as to the valuation or the lack of valuation in those long lists, it can be seen both ways, can't it? Because you're saying it's not just good enough to say, well, we'll get round to telling you what the cost of that is in the future. You're saying it's just a list, not saying it's just listing.
Yeah.
And it could be, yes, that's fine. Yeah, it's a bit creaky. Yes, it's absolutely terrible.
Well, quite, because as we understand the case, the list that I took your lordship and your ladyship to is the universe of remaining variations. But only some of those, I think 83.71% on the pleaded case, would be ones that damages were being claimed for. We don't know which. But more to the point, whichever ones they are, we don't have any explanation of what the breach of contract or negligence is, and we don't have any indication of what the case on causation and loss is. And that's because, as we understand it, Standard Life did not analyse those things. Instead, it wanted to run a case that you could infer from the 122 it did look at in unconnected by and large, and just assume, effectively, that if you've acted negligent in relation to the chimney, well, you must have acted negligent in relation to the basement. I mean, one only has to put the case in that simple way, which is effectively what this case is, to see how absurd it is, unless one is going to concede that professional negligence actions, for some reason, can be advanced in a way that defendants don't need to know about, and that defendants could ultimately be asked to pay damages in respect of matters they would still not know about, even after the judgment, because the damages would have been awarded on the basis of an assessment, an applied percentage from a discrete. And worse, even worse, the defendant would not be in a position to get Part 20 relief. How would it make a Part 20 claim against a sub-consultant? Or you saw in Item 1 in Schedule 1, where CJP and BDP were blamed for the same item. In a similar situation in the extrapolated variations, if this sort of claim was permitted to be advanced and tried and established in this way, how would a defendant make a Part 20 claim? It wouldn't be able to identify what part of the extrapolated claim damages applied to what, because no one had ever explained it to them. So in my respectful submission, it's the unjustness of permitting this kind of case off the blocks is compounded the more one thinks about it, when it becomes quite absurd, actually, to effectively be asking professionals to defend claims by reference to extrapolation based upon the inference of default negligence on unconnected other matters, which would lead to a situation where a defendant was potentially liable in damages for things it was never explained to it.
Mr. Brown, I don't know if you're going to come back to this Part 20 point, but at the moment I've got to tell you I don't understand it, because as far as I can see, it would still be right if it was right, even if they had told you all the things you want to know, like which category those variations fall into. You say you weren't told, and I understand that, for example, it wasn't said of variation X that it was an incomplete design case or that it was a steel category case. I get that you weren't, but I don't understand how, even if you had been, that would have solved the Part 20 problem you're talking about.
Well, I agree, if that's all that was given. I only made the point that not even a category was given, not because I'm not suggesting that's all that would have been required. No, I mean, just even categorising extrapolated variations would not explain the causes of action relied upon in relation to them, and would not enable a coherent Part 20 claim to be made. The only way that a coherent Part 20 claim could be considered would be if the claim against the defendant was understood in a conventional way. You would need to know what it was you're being criticised for, why, and what losses flowed. And if that related to, for example, the architectural, the landscaping, which features in there, or the highways, you may have other parties you would want to Part 20 for that particular part of the claim. But if the claim is articulated in a way that you can't possibly ever link the supposed claim for damages to any particular defect or default on the part of the defendant, and it has to be that specific, the defendant can't possibly not only understand the case it has to meet, but understand any case it might have against another Part 20 defendant. But I agree that the point wouldn't be answered just by categorising the extrapolated variations claim. I simply made the point that we didn't even get a categorisation, but that wouldn't be sufficient. All we have is a list of 3,000 odd variations, and then an assertion that however well we do on the 122, we can just infer that you were similarly negligent to the same extent, to the same value for everything else. But I'll come back, that's the essence of the point.
And if I've understood it right, that relates to your underlying submission, if I've got it right, which is that you don't have any difficulty as a matter of principle with extrapolation or sampling, but that you say you can only have extrapolation and sampling from a known whole. You can't have extrapolation and sampling as a starting point.
Yes, that's one of the ways we put it. So that takes me neatly onto the law, and the judge summarised the applicable law at paragraph 65 to 96 of the judgment, which is at page 138 of the core bundle. Now, three key principles are not controversial and were referenced by the judge accurately. I'll just quickly summarise them because I'm conscious we're in the Court of Appeal. First of all, the statement of case may be struck out if it discloses no reasonable grounds for bringing the claim or as an abuse of process or otherwise likely to obstruct the just disposal of proceedings. That's CPR 3.42. What perhaps is worth specifically going to is paragraph 1.4 of the practice direction to 3A, which gives examples of a particular claim that could fall within 3.42A. Unfortunately, the practice direction is not in the authorities bundle, but it is replicated at paragraph 34 of BDP skeleton, which is in the first core bundle at page 25.
This is the practice direction to
CPR 3. And we set out the practice direction subparagraph 1.4 gives examples of particulars of claim which would fall within Rule 3.42a, i.e. no reasonable grounds for the claim. 1, those which set out no facts indicating what the claim is about. 2, those which are incoherent and make no sense. And 3, those which contain a coherent set of facts, but those facts, even if true, do not disclose any legally recognisable claim against the defendant. And we would respectfully submit that in this case, this pleading fell into all 3 of those categories. And I'll come back to this because one of the errors the judge made was that he never actually specifically considered the question posed by CPR 3.42a by reference simply to the pleading, but we'll come back to that point. And in relation to abuse of process, we would just emphasise the example provided by, in the case of Towler and Wills, noted in the White Book, dealt with in our skeletons, that an unreasonably vague or incoherent pleading can amount to an abuse of process. Point 2, in terms of uncontroversial points of law that the judge correctly identified, that the particulars of claim must include a concise statement of the facts relied upon. That's CPR 16.4, and specifically, of course, in relation to the pleading of professional negligence claims, the following essential requirements were listed in the decision in Pantelli, and it comes from paragraph 11 of the judgment. It's referred to at paragraph 38 of our skeleton argument, but it's worth hearing out loud. The pleading needs to set out clearly what it is that the defendant failed to do that it should have done, and or what the defendant did that it should not have done, what would have happened but for those acts or omissions and the loss that eventuated. Those are the facts relied upon in support of the allegation and are required in order that the proper witness statements, etc., be obtained. Now, in my submission, there are 4 reasons why in any case, actually, but especially a professional negligence case, one need provide those facts. First of all, you need to plead a cause of action, which is the base requirement, so that facts that would generate a legal remedy. Secondly, the defendant is entitled to know the case he has to meet. Thirdly, it would be unjust if the defendant could be found liable to pay damages without knowing why. And fourthly, of course, it would be unjust if presenting claims in such a way inhibited any Part 20 claim, which we've already touched upon. The third legal principle that does not appear to be controversial is that the court should normally only reach a finding of professional negligence if there's been direct expert evidence on the issue. That's the Sansom case. Now, as we'll see, the judge, in my respectful submission, got the submission that was being made on the back of that principle slightly the wrong way round. And the significance of that general rule is that it presupposes, obviously, that there is an issue, i.e. an alleged breach, or facts that are said to constitute negligence, for the expert evidence to be adduced upon. And for fear of repeating myself, in relation to the extrapolated variations, of course, there wouldn't be. There's just a list of variations. Now, although not expressly noted in the judgment, in my submission, the following propositions, legal propositions, are also not controversial. First of all, the correct approach to an application to strike out a pleading is a 2-stage test. The first being whether there are no reasonable grounds on the face of the pleading, the claim, or whether there has been an abuse of process. The second question being whether the court should exercise its discretion to strike out the claim. And the authority for that proposition is the Cable and Liverpool Victoria case, which we've referred to in the skeleton, the decision of the Court of Appeal. The second proposition is that the question that arises under CPR 3.42a, so whether there are reasonable grounds for bringing the claim.
Sorry, the question arises under
3.4 subparagraph 2a of the CPR is a question of law to be decided on the face of the pleading. Just as an abuse of process is a question of law that needs to be decided before one exercises the court's discretion if it's found that there is an abusive process or there are no reasonable grounds for bringing the claim as a matter of law. It's at that second stage the court then says, well, what do we do about that? Now, in summary, in my submission, we'll see when we go to the reasoning shortly, the reasoning section, that the judge fell into error in this case in the following respects, 3 respects. Firstly, in his consideration of the legal principles that I've just summarised and that he summarised in the judgment, as it applies to cases involving the pleading of professional negligence claim, he fell into error because he simply didn't ask the relevant question and then didn't answer it, namely whether there were reasonable grounds in the face of the pleading, applying the need for a cause of action to be applied, to be spelt out, for a defendant to know the case it has to meet, for the facts relied upon. He listed out the relevant law, he just didn't then apply it to the pleading in front of him. Secondly, he didn't approach the questions. The reason he did that was he didn't approach the problem as a 2-stage test. He appears to have looked at it in a unitary way, merely as the exercise of his case management discretion. And thirdly, he introduced an irrelevant matter, namely similar fact evidence, which seems to be an adjunct to the second error, because the judge appears to have just analysed the question in a round way and veered into deciding it almost as a case management evidentiary issue rather than a pleading issue that had to be decided whether it was viable as a claim in the first place. Now, before I go to the reasoning section, if we just look in particular at how the judge dealt with the law, as far as there is any, on extrapolation, if we go to the judgment, paragraphs 81 to 87, it's at page 141 of the bundle. It's paragraphs 82 to 87, actually. I might just draw the court's attention just to a few of these paragraphs and then make submissions on the case referred to and the approach that we see developing by the judge in light of it. First of all, at paragraph 82, the first sentence, the judge records there's no dispute that in an appropriate case, extrapolation is permissible as a matter of law. And I'm just pausing there. Of course, extrapolation is permissible as a matter of law if you are, for example, seeking to evidence or sample a series of pleaded defects, such as the road patching in the Amy case, or an ordinary Scott schedule in the construction case. And then the judge goes on to refer to the Imperial Chemical Industries case, which is an example in relation to welding. Well, of course, it's permissible in that sense. And it can also be permissible in unusual cases in a pleading, as long as what you are pleading is a recurring, systemic, call it what you wish, breach of contract or act of negligence. What is not accepted is that in a professional negligence case of this kind, one can plead a case on liability, causation and loss by extrapolation, by comparing apples and oranges. And over the page, at 84, the judge referred to the decision of His Honour Judge Davies in the Amy case. And I'd refer you to paragraphs 84 and 85 because they isolate the important paragraphs from that case. And in 84, there's an extract from paragraph 1.26 of the judgment, where it was accepted by the court that it was open as a matter of law for Cumbria to seek to persuade the court to accept its extrapolation case on the basis of a representative sample as opposed to a random sample. So just pausing there, what one immediately sees is that the discussion in Amy, like in all the other reported sampling cases, is not actually opposite to this case. What Amy was about was how you prove an already pleaded case. In that case, there was a sample of 36,000 patches allegedly defective patches to roadworks. And the case was, here's my sample. These are defects caused by specific breaches of contract. I am saying, as a matter of representative sampling, that occurred in the remaining aspects of the works I've identified. So it's the repeating defect, the same kind of work, the same kind of breach. And what Amy was dealing with was just, well, how do you prove that when that is already pleaded? What we're concerned about in this case is the other question. When can you rely upon extrapolation to plead your case? Now, paragraph 85...
Is this right? In Amy, the judge rejected the extrapolation case on the evidence.
Yes. And found there was no alternative case.
As Mr. Justice Fraser did with the welding in ICI.
Yes. So on the evidence, there was already a pleaded case in ICI for the welds, which were an issue. There were already a pleaded case in Amy for the patches of road that were an issue. Each of those universes which were already pleaded, there was no quibble about the adequacy of the pleading, were then sampled, and on the facts, the sampling was found not to be representative. But the salient point for today's purposes is that those three cases are to do with using sampling and extrapolation as an evidentiary tool to prove an already pleaded case.
What I don't understand at the moment, Mr. Moran, is what is it saving you? What is the extrapolation saving you in the example you're giving? If you've got all that information about all of those instances, why do you need to extrapolate?
In the defect cases, such as
you call them, yeah.
Well, you're extrapolating, but in the very loosest sense of the term, because what you're really saying is you have committed this breach of contract 36,000 times, and that's where you've done it. You might call that extrapolation. You might just call that a repetitive allegation of breach that you just evidence by a sample. But the point...
Why do you need a sample? I mean, on what you're describing to me, I at the moment genuinely don't understand what it is you're describing as an exercise. If you seem to know everything you need to know about the entire universe, you don't need to sample anything. You just take one and say, well, that's it. We know they're all the same, so there's no difference.
Well, that would be the Cumbria's case in Amy. That was their case. In effect, we've got a sample. There's no difference. The judge found, well, your sample was not representative of what you're trying to extrapolate it into. But if the defects had all been the same, and if the sampling was statistically viable, and if the breach of contract for the sample defects were established, then the case would have been made out on the evidence.
But it's not, well, first of all, I don't understand why you just said statistical, because I thought the point of that case was it wasn't statistical.
Well,
they're not random samples, so it's not statistical sampling at all.
Well, that's right, but I think what Amy decided was it didn't have to be, as a matter of law,
right,
random sampling.
Yes, which
it could be representative. And so there was obviously an argument as to how one evidences and justifies that your sample sufficiently evidences the rest of the alleged defective works. And I think what the court decided was that you didn't have to have random sampling to do that. You could have representative sampling. And sometimes courts say there's a third alternative, which is sort of evidential. There's just evidence and you infer it from the evidence. But the point for present purposes is that what these cases are grappling with is an already pleaded case in relation to the universe that you're seeking to extrapolate into that's not being challenged as being inadequate. The reason it's not being challenged is because it's the very same defect that's happened again and again and again. Right. And so as a matter of pleading and evidence, one can sample and explain the case and evidence the case, potentially, by just looking at some of those. On the facts, the court decided not enough had been, or not, had either not been looked at or not in the right way. But for present purposes, my submission is that what these cases are doing are grappling with sampling and extrapolation in the context of case management to evidence an already pleaded case.
I know you keep saying that, Mr. Moran, but I think what probably is the core of what I'm putting to you is that I can see a continuum in which, and you're between cases maybe like the Amy and Cumbria case or the ICI case and other cases But on that continuum, what you have when you're, the reason, and we all know, the reason people are trying to do any sort of extrapolation or sampling is because you're trying to make it doable at a reasonable cost, because nobody wants to spend the cost and time if you don't need to, because you've got, and you're relying on there is an absence of information about the things that you're not focusing on. So if you've got a universe of 100, you choose 10, and that saves you the cost and bother of looking at the 90.
Yes.
And at the end of the day, this whole exercise is about trying to deal with the fact that you don't want to spend the time and money learning too much about the 90 when you can do it by looking at the 10. And that's what this is all about. And it seems to me that at the moment, listening to you, that there is, as I said, a continuum of what you know and what you don't know. And I'm not at the moment understanding what you're saying, which is a different, from my terms, from a continuum. You're saying that there is a difference in kind between what you call a case where the 100 are pleaded and the 10 are sampled, and a case like this case in which you're saying this is a case in which the 100 aren't pleaded, only 10 are pleaded. And I can see that there's a difference in quality, but I don't see it as being as fundamental as you're saying it is, because at the end of the day, it's just about what information you have and what information you don't have.
Well, if I could summarise our position, our case in this way. In my submission, extrapolation and sampling are tools recognised by the court as the basis for two different exercises.
Right.
The first is for proving, as a matter of case management and evidence, the existence of a wider group of individually defined breaches defects. And that's what Amy and those other construction cases are doing. There's no challenge to the pleading in those cases. There is, for good or bad, a pleading that identifies a number of alleged defects, and it's said that those are all replicated in terms of what's caused them and what loss flows from them by a sample of them. Now, that is one relevance of extrapolation and sampling. In unusual cases, extrapolation and sampling, we accept, could be used to plead a claim that goes beyond a small group of identified specific defects and breaches to capture an extrapolated universe. But, and this is where the learned judge went wrong, in those cases, it's still essential that a cause of action must be properly pleaded. Now, that can be done if you take the example of Amy and defective patches in a road. If you're pleading that case by way of extrapolation, you identify what the breaches are that have caused those problems in the road by reference to, say, 10 samples. And then you then say, we have got thousands of other similar patches, and our case is that they've been caused by those same breaches. So you have an identity.
Isn't this what Standard Life are doing by having a conventional claim as well as an extrapolated claim?
Well, we'll come back to what they're doing in a moment, but we accept that an extrapolated claim could form the basis of a pleading if the extrapolated claim is presented in such a way that you understand the cause of action, not just in relation to the sampled patches in this case, but also the universe of the extrapolated examples. And you do in the case of Amy, or a simple case for defects in the work, because it's the very same breach. So you understand in the extrapolated universe of examples of the breach what the cause of action is. It's the same breach that occurred in the sample. Now, in our case, in a professional negligence case, where the complaints are inevitably varied and fact-specific, even within the Schedule 1 that we looked at, Item 1, to do with service risers, is completely different to Item 2, to do with floor screeds. In a professional negligence case where you're saying, well, my sample is going to be based on certain categories of work and certain specific errors you made in relation to the timing of design information or the nature of design information, that is necessarily fact-specific to those items and those categories of work. You can't extrapolate in the form of a pleading that satisfies the rules of procedure and identifies a cause of action unless you're going to say those same breaches occurred in relation to similar kinds of work. But what happened in this case is that the extrapolated variations claim beyond Schedules 1 to 4 is not in relation to the same categories of work. It's to do in the main with completely different categories of work.
Right, but can you just humour me? If the extrapolated claim was on the same basis as the conventional claim, you're saying we wouldn't be here?
Yes, I'm saying if you could, whether in principle you could actually do that in a profit net claim, but I could imagine a situation where you might say that there are 100 houses, each of them are suffering from water ingress, which suggests there's a defective DPM. You, Mr. Architect, were supposed to inspect, and did inspect, all of those houses, but we're not going to go through and plead out the specific timing and nature of the defective inspection in every single house. We're going to look at 5 of them, and the case is going to be you were at fault because you did, when you did undertake your inspections, you didn't take any notice of an obvious use of the wrong material or something like that for the DPM. Now, you could understand if that were the nature of a case, a pleading, it would depend on how it was put, of course, but in principle, you could then extrapolate, in your pleading, you would say, well, look, here's my case on what went wrong in houses 1 to 5. Houses 6 to 100 have displayed the very same evidence of a defect. You did the inspections. We are going to extrapolate. We're going to say that you understand what we're saying in those other houses because of what we're saying in the first 5 houses. I could see how that could work, but that's a million miles away from what's happened in this case.
But if I can just understand this, if in the example you've just given, Mr. Moran, the 5 houses inspected had different defects, but it was quite clear, having analysed those 5 cases, that it all came down to a lack of professional care because the architect hadn't looked at the water tables or hadn't looked at the risers or hadn't looked at the materials that were going to be used. You're saying that that could or could not be used in relation to the 95 other houses where all of the occupants are saying something is wrong.
Yes. Well, of course, it's a question of degree, and it depends how it was put, but almost certainly it couldn't, because once you overcomplicate in a prof neg situation what the cause of the various defects, as you put it, in the 5 houses is, if there isn't a consistent explanation, a consistent kind of work that has been made defective as a result, then one can't just extrapolate as a matter of inference beyond that. Because if you were to try to do so, the defendant would not understand in relation to the remaining houses which of the various criticisms that you've made in the first 5 houses are applying to the others. It wouldn't know the case it has to meet.
You're making one general criticism, which is you have been professionally negligent and failed to carry out your duty of care to the house builder. So, I mean, so what would be wrong then in doing what, again, very simplistically, the judge said is, well, you know, if you've got a counter case, put it.
Well, you're verging there on reversing the burden of proof.
No, you're not. If you're saying to the judge as the plaintiff, we can prove in relation to the 5 houses that the damages that we are responsible for all derive from the lack of professional competence of the architect. And it's in different respects, but it all comes down to that. Then what's wrong with extrapolating from that and saying it's got to be logically
some kind of unidentified default. But because that boils down to suggesting that it's viable to make a professional negligence claim on the basis of identified negligence in specific respects, and then saying, well, we had similar problems or cost overruns elsewhere on the project. Because we've shown you were negligent over here, let's say in relation to the chimney, we can take it you were a negligent kind of guy, and we're going to infer, without explaining how, similar lack of care occurred everywhere else, to cause a similar amount of loss. Well, you could assert that. If you assert that, you're not complying with the CPR. You're not explaining what the cause of action is in relation to the extrapolated claim. All you're saying is you were careless. You haven't said how.
Well,
you haven't satisfied Pintelli. You haven't told the defendant what his case is.
But Amy, in coming before His Honour Judge Davis, said, well, you know, we've had all of these potholes filled, and look at them. They don't say, well, you know, in this one case they used the wrong tarmac, and in that case they didn't grind out the hole sufficiently well.
Well, from the judgment, we don't know exactly what the criticisms were. What we do know from the judgment was that it was considered to be a systemic allegation of breach. In other words, a repetitive error that caused repetitive defects. No one, I think, is disputing that in such a case, if that is pleaded, you have pleaded a viable cause of action in relation to the extrapolation. You have identified what the breach is, and you're saying, I won't go into the detail, but it occurred everywhere else over there. Well, that's a completely different kind of case to a professional negligence case where it's alleged that in relation to the cladding, say, you've provided late design information. Let's assume you have. What?
So you're not asking for detail?
Well,
No.
I'm not asking for detail. The law asks for detail in the sense of facts that sustain a cause of action. The procedural requirements require a claim that is viable to be pleaded. Pantelli tells us, in the context of professional negligence, what that requires. The defendant's entitled to know what he didn't do that he should have done. What is it that he did that was negligent? If you are trying to infer fault in relation to, say, the highways design from established fault in relation to the design of the cladding, then in my submission, the chances of that being accepted as being sufficiently probative are almost nil. But more to the point, for the purpose of the pleading, the alleged negligence in relation to the cladding tells you nothing at all about the cause of action relied upon in relation to the highways.
Well, why is that necessarily so, Mr. Moran? That's what bothers me about all of this. It all depends on the detail. So if for example, one of the alleged breaches, as I understand it, is uncoordinated design. Now it happens I'm looking at schedule, I think it's schedule 1, item 1, which I think you took us to, and it was uncoordinated design of service risers. Well, let's assume it's proved at trial that your client did negligently carry out do an uncoordinated design. It doesn't take a genius to think that if they did that for gas risers, they might have done it for I don't know enough about building to know, I don't know, drain pipes or something, whatever.
Might have done it. Well, I think on
might have done it was a polite way of saying the burden shifts to you to demonstrate that you didn't do it. And that explains why all these other ones are and you don't need a pleading to set all that out.
Well, with respect, I mean, if that were the approach to the burden of proof and the requirements for pleading a professional negligence case, then we would have opened the floodgates to spurious claims, which we suggest this claim was, based upon minimal identification of actual default, and then general assertions that you can infer from that there's been incompetence in all sorts of unrelated areas. That would just be heretical in terms of how one advances and articulates a professional negligence claim, or any claim.
I'm sorry to be heretical, Mr. Moran, but it seems to me that if I'm looking at a series of variations which offer this, I saw one when you were looking at them. The reason I was interested in ones that didn't have numbers is I was trying to find one that had a very small number, and I found one that was £128.
In the list?
In the list,
yeah.
Yes. £128 is lower than the irrecoverable cost of anybody looking at it in any detail at all.
Which begs the question, what's it in the claim for?
No, it begs the question of surely there must be a proportionate way of dealing with it.
Well,
the fact that you can stand on your dignity and say that they haven't said the words uncoordinated design approaching for that variation doesn't persuade me at the moment that it's a practical way of dealing with the claim.
Well, can I take those 2 points? First, the coordination point, and then the proportionality point. If there is established negligence in relation to the coordination of the service risers in the residential units in item 1, that tells you there's negligence in relation to that. Mm-hmm. It doesn't tell you anything about either the alleged negligence in relation to the highway variations or any of the other variations in the list. And it certainly, in my submission, would not by itself be accepted by a court as probative of evidence of negligence in an unconnected item of work. It simply establishes that item. And the suggestion that because you have been negligent in relation to 1 or 2 or even 100 variations, all that shows is that there is a case that's been pleaded and, let's assume, established in relation to those items. It doesn't by itself generate either a viable pleaded claim or a claim that has any chance of being succeeding on the merits in a negligence action unless, in relation to the extrapolated elements, there's an identified cause of action and expert evidence to support it. One doesn't just infer, in my submission, professional negligence on the part of a defendant because of negligence in some other aspect of the works. If that was all that was required, one would no doubt have some choice examples of negligence in a particular case, and then a case that you can infer everything else was done badly, even though I won't tell you how or with what consequence. I'm afraid it is.
Isn't it all a matter of degree, Mr. Moran? I mean, I completely agree with you that if there was, I don't know, I've forgotten what the universe of variations was, but a big number, it was several thousand variations, and somebody picked one variation and said, well, you were negligent on that one in this particular respect. Obviously, no one in no court, as far as I can imagine, is going to accept that an inference can be drawn from one example of negligence in a situation like that, plainly so. But somewhere along the line, as you count your way through the 3,000 variations, I can tell you, at least if I was the judge sitting in a case, there's going to come a point where I'm going to put up my hands and say, stop.
Yes.
And it's a question of detail. It depends on what these variations actually are, which you can tell to some extent from just looking at the list. It depends on how much they're worth. It depends on everything. And it just simply isn't, just as it's obviously not true to say that if you pick the uncoordinated design service of the gas risers, you can't infer from that one data point that something to do with the drains was necessarily negligent or not. That's true. Equally, the converse is also true, that you can't say that once you've gone through 150 of them, that you can't start drawing inferences about the remainder, because you plainly can.
Well, in my submission, it's not just a question of the number. What's critical is what you're extrapolating the identified breach into.
Yes.
And my submission is that the essential requirement has to be, on any pleading, but most of all a professional negligence pleading, see Pantelli, that the defendant understands what he's being criticised for in relation to a particular claim for damages, in this case the extrapolated variations. Now that can only be done in the context of a professional negligence claim by saying, in relation to the extrapolated items, you were at fault in the same way as I'm identifying here, which I think is what your lordship was postulating, is what happened in Amy. Well, we accept, although it's difficult to articulate what facts would actually, in a prof neg architect's case, would fit into that. In principle, I'm sure that's right. But in this case, if you are seeking to extrapolate from apples into oranges, if you're saying my extrapolated works are in large part in parts of the works that are nothing to do with the sample I have looked at in detail, one can't possibly, in my submission, extrapolate a case either as a matter of pleading or evidentially, with any real prospect of succeeding, simply on the basis of what you have sampled. Because by sampling and explaining negligence in relation to, say, the cladding, doesn't tell you anything at all about what the alleged negligence is in respect to the highways. And also, even if it's established in relation to the cladding, that doesn't tell you anything of probative value in relation to whether or not there was similar or different or whatever negligence in relation to the highways. And if the court was to permit this kind of pleading to be viable, it would lead to cases of extrapolation in prof neg cases, spurious ones potentially, simply on the basis of relatively minimal amounts of analysis, large extrapolation, sufficient to get over a strikeout obligation, putting undue commercial pressure on the defendant and the defendant's insurers, cases that will no doubt mainly never get to trial to figure out what the real answer is. But the court will be opening the door to an abusive process in effect. Claimants pursuing claims that they don't know they have. They're just asserting in the hypothesis your lordship gave me, that because there's some fault on coordination in relation to the service risers, that's indicative of general carelessness, and we're going to have a stab at saying, oh, well, 80% of the rest of the variations were probably caused by some unidentified negligence. Well, if that were permitted as a way to present a claim, notwithstanding no viable cause of action being explained, notwithstanding the CPR not being complied with, what you will have done is permitted effectively an abuse of process.
Well,
Claimants to run cases
the abuse of process at one end, and the abuse of process at the other is what Lord Dyson called the grinding detail of these cases.
I agree.
I mean, a very well-known construction advocate has just retired from advocacy after 40 years, and his biggest boast remains that he was allowed to cross-examine for half a day about an allegedly defective doorbell. And he now says that was probably an abusive process, but in 1985 he was allowed to get away with it.
Well, I accept that it's a question of degree. And
I think that's where we get to.
That's where we get to.
It is a question of degree, and so then it becomes a question of, I mean, that's not to say there aren't principles involved, because speaking for myself, I think there are, but I think quite a lot of this is, one way or another, a question.
It is a question, but degree not just in terms of the number that you're extrapolating from, but the nature of what you're extrapolating from and into. It's both. And our submission, in terms of the law, is that whether or not a claim is expressed in the pleading to be based upon extrapolation or just a conventional, here are all my alleged defaults, it's still required to comply with the CPR and Pentelli. So the cause of action must be identified. The defendant must know the case he has to meet, because the defendant might not be happy to rely upon arguments over random sampling. He might want to look at some of the extrapolated variations and say, this doesn't relate to fault on my part. How is he to do that if he's got no idea in relation to any particular extrapolated variation what the criticism is? Because as your lordship's pointed out, in this case, even on a category basis, there were 4 categories of breach in Schedules 1 to 4. So any extrapolated variation, the defendant seeking to defend the claim wouldn't even know what category of breach the extrapolated variation fell into. He'd be completely into the dark as to how he was supposed to respond to it. He would then, as I don't want to repeat myself, be potentially at risk of paying damages in respect to defaults and having reputational damage in relation to professional negligence, in relation to items of the work that have never been identified to him, just assessed as an extrapolation from those bits that were identified.
But in this case, you have, and you've complained, that there are many, many, many items identified. So he will have the items identified. And I really do go back to the question. You made clear that you are not here, and neither were you before Mr. Justice Carr, complaining of the pleading in relation to the conventional claim.
No.
No. So, but your case is, it cannot be right to permit the respondents, the claimants in the court below, to extrapolate on the basis that they have pleaded, although you will counter, a specific cause of action.
But in relation to the extrapolated variations, they haven't pleaded a specific cause of action. What is the breach in relation to any one of them? We don't know. The plea doesn't tell us.
So if there's some suggestion that the use of the word mutatis mutandis refers to the fact that they're saying that the same breaches have occurred, as in the conventional claim, and you took objection to those 2 words.
Yeah, but if one asks rhetorically, what on earth does that mean, mutatis mutandis, when you've got 122 specific breaches, admittedly in 4 categories? What on earth does that mean applied to 3,000 odd variations without any explanation of, even by a category basis, which variations fall into which category? What can mutatis mutandis really mean?
You have the case pleaded, you don't have the detail, and my lord's point about the question of detail then goes into the degree, and it can come up with items with £124 attached to it, or no value at all. But you know the cause of action, which is you have been professionally negligent in this regard, and this is the conventional claim.
In the Schedules 1 to 4, yes, we know the cause of action. But we're not complaining about Schedules 1 to 4. We're complaining about the extrapolated claim.
I know
beyond
you are. I do know you are. But it's just that you're looking at it as though it's completely distinct from the conventional claim.
Well, in my submission, it is, or it's sufficiently.
Piggyback on it.
It's sufficiently distinct to make the pleading unviable. One only has to ask the question in relation to any one of the extrapolated variations. Even what category of breach applies to it, one doesn't get an answer. That means there can't conceivably be an identified plead cause of action in relation to any one of the extrapolated variations. It's incoherent gobbledygook. How could a defendant defend it? Couldn't. My submission.
He could put a positive case, of course, couldn't he?
Well, before we get on to positive, before we get on to how we respond to it,
Well,
one looks at the pleading.
That was just a question in general. He could put a positive case and say, this is the conventional claim, this is the extrapolated claim, but we can point out, as you've been indicating by going through the amended pleadings, we can indicate that this is completely out with.
But well, I ask rhetorically again, in relation to the extrapolated claims, if there's no identified case on breach or causation of loss for any one of them, which there isn't even a categorisation, how on earth would a defendant, even if it wanted to address them to rebut the case in that way, know what it's supposed to be rebutting for a particular variation?
Well, why not rebut the four? I think is it 4 types of negligence that were pleaded? 4 breaches: uncoordinated, design, late design. I can't remember the others. Why not look at the £128 one and say, right, well, we can see that design wasn't late, it wasn't uncoordinated, it wasn't the other thing, and it wasn't the other.
But with respect, what you're postulating there is a defendant picking up an item and thinking through the ways it could possibly be put against
the way it's
negligence.
put in the pleaded claim against.
But with respect, if you just adopt criticisms at that high level of generality, so uncoordinated design, that's not a sufficient way to plead a professional negligence case. See Pantelli, see the CPR. If you picked a particular item and said, okay, let's assume there's a coordination criticism applied to this, how would you know what the criticism is? You wouldn't. How would you? Then you say, actually, let's put our late instruction hat on. Let's look at this item. Now, is this late? How would you know what is alleged to be late if it's not explained? You'd be put in, and that's why you're being put into an unjust position by a pleading of this kind, and that's why it doesn't comply with the CPR. The overriding objective requires pleadings to be just, a point the judge acknowledged. But then he lurched, in my respectful submission, too much into proportionality. And I wanted to take your lordship's point on that, because proportionality doesn't come into it, in my submission, when one is first assessing on the face of the pleading whether the required causation has been pleaded. Proportionality becomes relevant in terms of the second stage, in terms of exercising your discretion as to what to do about an inadequate pleading, or it comes into the question of case management, how you evidence an ordinarily well-pleaded case of many default. It's no answer. If I make a claim in court and I say, look, I've got a terribly good case, and I'll tell you it's worth £100 million, but it will cost me the earth to tell you what it's about. That's no answer to not telling anybody what it's about. Proportionality doesn't explain or excuse, under the rules and the law. Latang and Cooper didn't say that a cause of action only depends upon facts that disclose legal remedy, brackets, if it's proportionate. A cause of action is a cause of action. You either express it or you don't. If you can't because you haven't been bothered to look into it, then that's just your problem. So proportionality is a matter of principle, cannot excuse a deficient pleading that doesn't plead a cause of action. If it did, no doubt litigants would come to court and say, well, I can't tell you all about my claim because I haven't got the wherewithal to do it, but take it from me, there is a claim. And look, there's some other negligence I can point to that shows this defendant might be negligent generally. I mean, it's just, in my submission, taking the pleading and court process to an utterly unjust limit to say that you can excuse the inadequacies inadequacies in this kind of pleading in a £38 million case on the basis of proportionality, especially in circumstances where we've seen that when only the 110 were in fact looked at over the next 6 months, 90% of the extrapolation claim disappeared. But the point of principle is, in my submission, that proportionality isn't an answer to whether there's an abusive process or whether there's no viable claim on the pleadings. It doesn't come into it. That's just a question of law to be looked at on the pleadings. Is there a cause of action? Is there a cause of action that complies with the CPR as explained in Pantelli? It's no answer to say, I'm sorry, it would have been disproportionate for you to explain to you what the cause of action is. There isn't a cause of action, full stop. Proportionality then comes into the second stage. What do you do, if anything, in response to that? Do you strike it out or do something else? And when we get to the reasoning of the judge, we'll see in my submission that where the judge went wrong was that he just merged all these issues of proportionality, etc., into one unitary approach. And if he had approached it in the two-stage way, and if you reach the conclusion on a case like this that £20 million of it is based on thin air, in effect, and that there's no limitation issues, the matter can be gone away and investigated, as the Standard Life did in fact do, come back another day when you've actually looked at these variations and told us what the case is, which is what's happened. But if you get to the stage that the pleading itself is not viable, either as an abusive process or because it doesn't plead a cause of action, in my submission, there would be no reason to exercise the discretion to nevertheless let the pleading in. In fact, all the factors would point towards kicking it out. And in reality, what the judge did in this case was kind of fall between two stools because, as we'll see in his reasoning, there's plenty of acknowledgement of the unviability of the pleading. But instead of just doing what we say was the obvious thing to do, and just strike out the extrapolated claim and say, come back with a new claim, the judge effectively sort of had it both ways, decided not to strike it out, but nevertheless ordered the claimant to provide further particulars. So in our submission, that really is a sort of hint towards what really the obvious answer was this was an unjust, unviable pleading that should have been struck out, and then the claimant would come back, as it has, with specific causes of action pleaded in a conventional way. Just before I move on to the reasoning, similar fact evidence was introduced as relevant at paragraphs 88 to 90 of the judgment. The summary of the law of similar fact evidence is uncontroversial, but in my submission, it should not have been relevant to the issues that the court was being asked to consider. Neither party referred to similar fact evidence as relevant to their cases. And in my submission, similar fact evidence is not a relevant consideration to whether or not the pleading discloses reasonable grounds for a claim. That's because reliance on similar fact evidence assumes that there is already an adequately identified case on breach that the similar fact evidence is sought to relate to. But the issue in this case was whether or not there was in fact an adequately explained case on breach. So the suggestion that similar fact evidence, even if it existed, could somehow exculpate the pleading was in my submission an error. Similar fact evidence only becomes admissible if there is already a viable pleading. That takes me to the judgment. The reason this is part 5 of my submissions. I think I'm maybe go a little bit over lunch, but not much.
That's all right.
The judge's reasoning is set out at paragraphs 102 to 133 of his judgment, which appears at pages 151 onwards. And I'm sure the court has considered this passage in particular carefully. And so if I may, I will just trot through some of the paragraphs and focus on one or two of them, noting some points as I go. And I'd like to start at paragraph 106, where the judge actually accepts that some parts of the pleading invite inferences that could not be drawn by a reasonable judge, and then refers to cases in point that he's identified above, but not suggesting that those are the only ones. So the reasoning starts with a suggestion that the defendant's case, at least in part, is made out. At paragraph 107 then, with respect, the learned judge missed the point that was being made in regard to expert evidence. Where he found the pleaded breaches of professional duties are detailed and then refers to Schedules 1 to 4, it's plain that expert assistance has helped inform those parts of the pleading. That's not the point that's being made. We're not criticising Schedules 1 to 4. The point that was being made was that if, as is usually the case, a case of professional negligence requires relevant supportive expert evidence in relation to breach, that would not be possible in relation to the extrapolated variations claim, because in relation to every single one of the 3,000 odd variations that make it up, there is no explained case on breach, and therefore there could be no relevant expert evidence adduced in due course. That was the point that was being made, effectively just a development on the point that there is no pleaded cause of action. Then at 108 over the page, the judge rejected abuse of process on the basis of getting improper commercial advantage, and then distinguished the case from the Macur case. But again, with respect, the learned judge missed the point that was being made. On the Standard Life's own admission, it doesn't know what case for breach of contract or negligence could be within the extrapolated variations, because it hasn't analysed them. It is making what we say is an unviable averment that you can infer unidentified defaults from the categories of work that are pleaded properly in Schedules 1 to 4. So on the claimant's own case, it doesn't know what its case on professional negligence is in connection with the extrapolated variations. And therefore, by analogy with Macur, that is a form of abuse of process. At paragraph 109, the judge seems to accept that the claim is inflated by way of impermissible inferences, and then introduces proportionality as implicitly relevant or an excuse for that. But for the reasons I've already given, proportionality isn't relevant at this stage, at the first stage of the analysis. It's not relevant to the question of whether the pleading discloses reasonable grounds for the claim or it represents an abuse of process. At paragraph 110 to 111, the judge suggests that the defendants know the case they have to be and finds the extrapolated case does not expand the pleaded breaches of duty. Now, in these paragraphs, the judge seems to be referring to the Schedules 1 to 4. Well, yes, the defendant obviously understands that part of the claim. It also understands at a very high level the bare assertion that you can infer unidentified fault elsewhere because of what is in Schedules 1 to 4. We understand that. But the essence of the objection is the essence of my submissions today. What we don't know in relation to the extrapolated variations, or any one of them, is what the breach of contract and negligence actually consists of, or what loss is supposed to have been caused as a result, and how. Not one. So the judge, in my submission, misunderstood the submission that's being made. Plainly, we understand the Schedules 1 to 4. We don't complain about Schedules 1 to 4. We don't understand, because no one has explained, what the culpable conduct is in relation to everything else. Paragraph 112 suggests that the breaches for the extrapolated claim are the same as the Schedule 1 to 4 variations. Well, this is, I think, the point I've already had an exchange with the court on that. Presumably that's, although it's not referenced to the mutatis mutandis. But there is, save for the, we would say, incomprehensible averment of mutatis mutandis in this context, there is no indication, even by a category basis, of what the nature of the breaches it suggested relate to the extrapolated variations. And that's for good reason, because, of course, Standard Life hadn't analysed any of them. At paragraphs 113 and 114, the judge correctly finds that there's no systemic breach. And what we meant by systemic breach was a a replicated alleged breach of contract or act of negligence, which we say is essential if you're going to extrapolate a claim in a professional negligence claim from an identified example of negligence into others that you're asking for the inference of the same default to have been made into, then you have to have a pleading of a systemic breach, the same breach. Just as in Amy, it was the same defects, presumably, that were replicated in the patches, and the same breaches of contract that were said to apply to all of them. If it's systemic in that nature, as Judge Stephen Davis found in Amy, or systemic in the way that I've described conceivably in a prof neg claim, one could see how the pleading would be viable. But that's a million miles from this case. And it was not alleged that the same breaches occurred, other than in the throwaway reference to mutatis mutandis, which, for the reasons I've given, is simply an incomprehensible plea when you're referring to 122 variations to do with 4 categories of work, and you're suggesting that that somehow explains the breaches of contract and negligence relied upon in relation to 3,000 odd variations in different categories of work.
I would be a bit troubled about saying that it had to be systemic in order to be capable of an extrapolation exercise, because that sounds as if it's sort of setting up another potential hurdle. It would always depend on the facts of any particular case, wouldn't it?
Well, I think it would depend on the facts of a particular case.
I mean, it's easier to see why you would extrapolate in a case of systemic defects. Just speaking generally, I get that. But I don't think it necessarily follows that therefore you need the defects or the underlying allegations to be of a systemic nature in order to say you can therefore have sampling.
Yeah, I think it's difficult to generalise at that high level at all. But I suppose you could. So, for example, in my example of the contract administrator who is negligent in relation to 10 or 100 houses, you might say that the allegation of negligent contract administration is not really systemic in the sense that it will be slightly different in terms of timing and what was looked at in each house. But the essence of the criticism, so that it could be understood as it applies to every house, would be capable of being pleaded by reference to 1 or 5 of them. But the reason that would satisfy the requirements of the law in terms of identifying a cause of action and the CPR properly pleading a case, and Pantelli telling a defendant what it is he should have done that he didn't do, is because there is such similarity between the conduct. It would be understandable as to what the defendant was being criticised in relation to all of the houses, even though only 5 of them had been explained in detail. So one can see then, taking Lord Justice Coulson's point, that whether you describe that as systemic or not, you can see that that kind of pleading might satisfy the CPR, establish a cause of action across all the 100 houses, even though it's only spelt out in relation to 5. But that is a million miles away from this case, because we are dealing with different work categories, as between Schedules 1 to 4 and everything else, different types of breach, the categories, and there's absolutely no explanation in relation to any one extrapolated variation where it falls. And it's really not for the defendant to be preempting any possible conceivable criticism of every single variation to defend such a claim. The reason we would submit that the rules are as they are in the CPR is to prevent that sort of disproportion, having to disprove or prove a negative, taking place in a professional negligence claim. Then going back to the judgment, at 115, there's a rejection that only systemic or recurring breaches would make a professional negligence pleading viable. But at this point, the judge in my submission, and it's throughout this passage, has now divorced the reasoning from any recognition of the need to actually satisfy the CPR and address his attention to the requirements of CPR 3.42a, which is what the application was being made on the back of. Because as he says, there's no magic or precision in the word systemic. So just then finding that it doesn't have to be systemic doesn't answer the question that he's being asked to consider, which is whether this pleading satisfies the CPR and as a matter of the overriding objective and the just resolution of disputes should be permitted to go on. At this point, the reasoning becomes generic, unitary, not focusing on the specific question that had to be addressed in the first place, which is whether this pleading, as a matter of law, disclosed a cause of action, in effect. Now, at 116, then, as the learned judge develops his point that one doesn't need, or that such viable cases should not be limited to systemic case breaches, he then gave an example of no system at all. He said, where the defendant operates no system at all, but fails to perform properly in the same way repeatedly, well, this is being proffered as an example of a non-systemic breach, but in my submission it reads as if it's a systemic breach, and it's not analogous anyway to the facts of the case, the pleading in this case. Throughout this passage, the judge doesn't address his mind to the key point, which is how do you answer the objection that one cannot infer negligence, let alone, and certainly not the nature of the alleged default said to underlie the negligence, in connection with, say, the late design of the risers in the residential flats, with whatever it is that's behind the variations in the highways or the landscaping. You can't. It's not identified in the pleading. It couldn't conceivably be inferred as a matter of evidence. And at no point does the judge address that particular point. This pleading, is it sustainable or not? And then at 117, again, there's a further analogy of drawing inferences, and then he introduces the similar fact evidence analogy. But again, the judge seems to posit the kind of systemic breach that we say is required in these kinds of cases to make them viable on the pleading. And in any event, of course, as I think I've already acknowledged to the court, ultimately this would all depend on how it was pleaded in a particular case. Paragraph 118 is notable because the judge again accepts there are parts of the pleading where inferences sought cannot be made. But rather than then grappling with the consequences of that, it's kind of swept up in a general approach on a proportionate, discretionary basis, which is just not answering the question that he should be first answering. And at 119, we get the finding that the defendants have pointed to specific examples of instances where it is necessarily bad, i.e. the extrapolated case in the list of variations. But if a judge were to go through, line by line, with a fine-tooth comb, each and every part of the extrapolation exercise, it's likely the judge would find parts of the extrapolation case that are fit for trial. And then we get that leads into paragraph 20, the wheat and chaff paragraph. It's likely there is wheat as well as chaff in that part of standardised claim comprising the extrapolation balance. I accept I make that judgment partly as a matter of impression. So what the judge appears to be doing here is, as a matter of impression, asserting that as a matter of fact, ultimately there might be something in this, is what it comes to. But that's not the question, that's not the exercise he ought to be undertaking at this stage. The first question is this a viable pleading? That's got nothing to do with whether, come the trial, there will be wheat as well as chaff in the confetti of allegations that make up the extrapolated variation claim. And then if we move on to 122 to 123, the judge rejects the strikeout application, but without deciding or even posing the initial question required by CPR 3.42a, the first stage test. Does the pleading, construed as a matter of law, display reasonable grounds for bringing the claim? And for all the reasons I've made, the requirements of the CPR as to what that must contain, the explanation of that in Pantelli, the base requirement that there needs to be a cause of action that can be responded to, the issue of justness, the defendant needs to know what the case is going to be against him. He needs to know after a trial what it is he's paid damages in respect of. On the judge's approach, the defendant could end up paying damages and never knowing in relation to what bits of the extrapolated variations claim those damages relate to. So that brings me to my final part of my submissions, and I don't want to, I mean, I've made, I think, all of the points, but if I just draw them together.
Hang on a minute, I'm just looking to see what 6 was.
Part 6 is the summary. Ground 1.
Summary of why you say the appeal is allowed.
Why the appeal is allowed. Ground 1 related to the extrapolated variations claim. And we submit that the judge was wrong not to strike out that claim for 3 main reasons. First of all, he approached the question in the wrong way. And I've sought to explain, by reference to the reasoning passage in particular, how the judge effectively approached this in a unitary way, as a general exercise of case management, emphasising proportionality, etc., but before addressing the first stage, which the Court of Appeal says is the first stage, which is, does the pleading as a matter of law amount to an abuse of process or not satisfy the requirements of CPR 3.4a? And just finish that point off, that is what the judge was doing, and my submission is also indicated by the reasons the judge gave for not granting permission, which are at page 160 of the first core bundle. In the second paragraph, I accept that the refusal to strike out or grant summary judgment is not just a matter of case management, but in the present context, the outcome of the application was very substantially one driven by case management decisions to make the claim manageable, etc. So what the judge doesn't do, either in his judgment or in his reasons for refusing permission, is say, well, no, actually, I've looked at the pleading and it does disclose reasonable grounds for bringing the claim, and these are they. And the answer to the objection, there's no cause of action pleaded for the extrapolated variations, is this. And the other objections founded on the CPR and Pentelli are answered by that. It's just not done, because what the judge has fast-forwarded to is effectively a case management exercise, implicitly assuming that the pleading is the best that can be done and is all we've got, and we've just got to manage the further development of some aspects of it and then make this manageable at a hearing. Well, that isn't the exercise that the court was being asked to do. The second reason ground 1 should be permitted is that, as I've, I think, submitted ad nauseam, the relevant parts of the Part B amended particular claim did not disclose reasonable grounds for bringing the extrapolated claim and or an abusive process, because there were no adequate facts pleaded to explain what the claim was about in relation to the extrapolated variations. There was no viable pleaded cause of action in relation to any one of them, case of systemic breach that made any sense beyond the throwaway reference to mutatis mutandis, or other factual basis for liability in respect of the extrapolated variations to be inferred reliably from the small number of 122 variations that were explained in relation to different categories of work. In short, Standard Life were advancing an unviable professional negligence claim in connection with over 3,500 variations, merely on the basis of 122 that they had examined that were not themselves part of the extrapolated claim and were mostly connected with other categories of work. To permit professional negligence claims to be pleaded in that way would be to open floodgates and encourage spurious claims based on extrapolation aimed at putting commercial pressure on defendants and their insurers. It would also fundamentally undermine the defendant's right to know the case it has to meet evidentially before the trial, and to only pay damages ultimately in relation to criticisms that were articulated and understood. And if this pleading were permitted to go to trial, the defendant would be at risk of being ordered to pay damages in relation to matters that were never understood in terms of a professional negligence criticism. That, in my submission, would not just be unjust, would be absurd. it would also create, for the reasons I've given, practical and legal problems in the defendant seeking to pass off or seek a contribution to such liability from other parties, because it wouldn't be in a position to identify what aspects of the works that inferred extrapolated liability related to. And the third reason that ground one should succeed is that the judge overemphasised the assertion that it would be disproportionate to expect the claimant to plead out its claim. Now, the first point on that is, of course, it's not accepted that the issue of proportionality was actually relevant at all to the first stage of the test. But in any case, the claimant was in truth obviously in no position to assert that it would actually need to examine and plead 3,000 odd variations. All it could say was that there were 3,400 odd variations which it had not even looked at. It had no idea of whether 100, 200, 1,000 of those actually had a viable cause of action lurking underneath them. And so the assertion that there were, in fact, 3,482 individual cases of negligence that would have to be pleaded if the case was to be advanced in a conventional way was on its face absurd. That could not be contended. Nobody knew what was in underneath those variations. We now know, because we now, since the strikeout, know that after just reviewing a further 110 variations and pleading some 50 odd of them, the need for 90% of the extrapolation claim went. So not only was there no reasonable ground at the time of the application to suggest that there would in fact be a need to make another schedule with 3,000 odd items in it, we now know that wasn't necessary. Now, in relation to ground two, the extrapolated loss and expense claim is essentially parasitical on the variations claim. It said that the damages referable to the extra loss and expense that were paid were caused by delays, themselves caused by the defaults that generated or generate the variations claim. So to the extent ground one succeed, ground two should also succeed.
There's no difference, is there? There's no new or different point of principle
well,
in ground two.
Save that the loss and expense claim is even more remote from reality than the variations one, because it literally applies the percentage, the 83% figure of the 55% of the Schedule 1 to 4 variations that were actually analysed and found to be design team culpable. It then just applies that percentage to a global figure for loss and expense that's been arrived at by taking the overall loss and expense payment to Costain, I think 20 million odd, and taking out of it matters that Standard Life accept they were responsible for, or that Costain didn't blame the design team for. Everything else is just left in. That gets you to 10 million. One then just extracts the direct loss and expense claim of 6